Hello, everyone. My name is Giovanni Nogales, and I'm a paralegal here at Lyles Parker. Thank you for joining us for this new webinar series with the Home Care Association of Louisiana. Today's webinar is entitled Personal Care Audits and Enforcement in Louisiana. Our presenters for today are Les Johnson and Ashley Morgan. Les Johnson helps clients navigate the myriad of regulatory, compliance, and business issues facing today's healthcare providers and practitioners. Core areas of Les' practice includes handling Medicare and Medicaid appeals, Medicare and Medicaid participation, and compliance. Les assists clients with operational and business issues involving hospital medical staff relations, practitioner credentialing, healthcare contracting issues, mergers and acquisitions, antitrust hurdles, joint ventures, practice formation and restructuring, Stark and anti-kickback law compliance, state self-referral prohibition, and any other regulatory issues a client might face. As for Ashley, she is a partner in Lyles Parker's DC office. Ashley focuses her practice on regulatory healthcare compliance matters, fraud and abuse, and reimbursement issues. Ms. Morgan represents healthcare providers across the country in connection with a wide variety of health law issues, including coverage disputes, documentation concerns, compliance, medical board complaints, and exclusion termination issues. She has worked with an assortment of providers, including home health companies and hospice agencies. Ms. Morgan is also a certified professional coder, a certified medical reimbursement specialist, and a certified medical compliance officer. This is just a quick reminder. If you have any questions throughout the presentation, please feel free to type them in the chat box. We will address as many as possible at the end of the presentation. You guys will also receive a copy of the PowerPoint slides tomorrow via email. So without further ado, I present your speakers, Ashley Morgan and Les Johnson.
Thank you, Gio, and thank you all for joining us today. Les and I are going to be speaking with you all about personal care audits and enforcements in Louisiana. We can go ahead and go to the next slide, Gio. Just a brief disclaimer that this outline is being provided as general information only and does not constitute legal advice and should not be used as a substitution for seeking legal counsel. Outcomes can always vary depending on your specific case facts, so you should always consult your healthcare legal counsel with your specific questions. Next slide. Okay. So today we are going to review what can trigger a personal care audit, some sample audit and inspection plans that we've seen from OIGs around the country that are looking at personal care services, an overview of the False Claims Act, an overview of the anti-kickback statute, two big enforcement tools that are available to the government in connection with personal care services, some recent enforcement trends that we're seeing around the country, and tips when you are responding to an audit or an investigation. So, yep, next slide, thank you, Gio. So what can trigger a personal care audit? We have a couple of examples for you on the board. Services being billed without supporting documentation, that's a big one. It's really critical that if you are billing for personal care services, that you train your personal care attendants on what that documentation needs to look like. You need to have that documentation to justify the services that you are billing out to various payers, including the government. In connection with that, it's not enough just to prepare documentation supporting those services. It needs to appropriately meet the criteria for coverage and payment. So you need to make sure you understand what those coverage requirements are. Another big issue we see are services being billed that are ineligible for reimbursement, either because they don't qualify for the individual's plan of care, or, if they're not meeting those coverage requirements that I was just speaking about, if you're, just not properly documenting the services, or if you don't have a signed note, signed plan of care, a variety of different reasons. Another big issue we see are services that are being provided without the required supervision. This can vary depending on the state, depending on the payer. But the supervision requirements that are required for your personal care attendants. So if those are not meeting the supervision requirements, or if that supervision isn't documented properly, you can't prove it, then we see that being an issue as well. Services being provided without state verification of qualifications. So, you know, if you have not properly verified your agency or your personnel, that's a big issue. Services provided during an institutional stay, we'll talk about that a little bit more, but generally personal care services cannot be provided during institutional stays such as hospital stays. And general fraud, waste, and abuse. I mean, billing for services not rendered, making up, you know, services. If you have PCAs who are documenting that they went to a person's house and they didn't actually go, all things like that can lead to an investigation. Thank you, Gio. Services being billed without supporting documentation. This is a biggie. You know, it's really, really important that your personal care attendants are educated on what the requirements are for coverage and payment. Because if you don't have the paper to back up the services that are being provided, then I mean, it may as well be like the services were not provided, because that is your only real justification. If somebody comes in and wants to look and see, you know, what's been going on, can verify the services, that's really your only source of justification in an audit situation. Providers have to keep records to ensure that services were provided, and you need to make sure that they actually meet the coverage requirements. As I was saying previously, your requirements for what needs to be documented, it's going to vary depending on the payer. So it's important that you review all of those requirements and understand what different payers require. If having too many different moving targets is too much for you, then I encourage you to identify which payer has the strictest guidelines and abide by those for everybody. So you don't have different requirements for different payers. You just have one that meets the strictest requirements. Documentation requirements generally include that the rendering personal care attendant and the dates and hours of the services be provided are being documented. Louisiana has some specific rules that we're going to talk about, but it's really important that your personal care attendants are documenting the date of service and the hours that they're in the session, the start and stop time, not just total minutes. We want to make sure we're documenting start and stop times for these services. Personal care service providers are required by federal law to retain healthcare records for at least 6 years from the date of creation. Sometimes payers have longer requirements, but that's your bare minimum. And again, you may be required to retain records for a longer period than that. And generally, if you're providing care to a minor, the requirements can be longer as well. Claims being paid without supporting documentation are considered at best an overpayment by the government. They could also be considered, you know, billing for services not rendered, which would be an allegation of fraud. So very important, again, that those services are properly documented. If the government identifies a pattern or lack of supporting documentation, then an audit or investigation may be triggered. Audits and investigations can be triggered in a variety of ways. But if, you know, they get a tip that, you know, if for example, from a prior employee or a current employee that says, you know, you're not meeting the coverage requirements, that's certainly something that the government's going to look at. Or if they even just do a regular, you know, generic compliance audit, request a few dates of service, if they see something within those notes that they think might indicate that there's a larger problem, they can absolutely expand that audit or refer it to fraud investigators. Next slide. Services billed that are ineligible for reimbursement. So some common examples of this are billing for services for beneficiaries that aren't actually eligible for Medicaid. So important that you verify benefits before you begin rendering services and billing Medicaid for personal care services. Services that are not documented in the plan of care. It's important that you are only providing services that were specifically outlined in that specific patient's plan of care. We're not going to get reimbursed for services that go outside of that plan of care. If you think that the plan of care is insufficient, that's something that needs to be addressed separately. We can't just decide, that we want to add on additional services and we're going to try to get reimbursed for those. Services exclusively provided to other members of the household besides the beneficiary. When you are going into people's homes and supposed to be rendering care to one specific person, you cannot, be in there for an hour assisting another person in the home with their care. It needs to be the services that were ordered for the beneficiary themselves, whatever that might be. You cannot be also then, spending time providing assistance to somebody else within the home, unless for some reason that was indicated in the plan of care. Highly unlikely, because that plan of care should be tailored to the beneficiary. Provided by a personal care attendant without verified qualifications. It's an important one. We really need to make sure our PCAs are qualified to actually provide the services. This is something that we see a lot, where a screening hasn't been properly done, and can lead to much larger issues. For example, if you have somebody that's excluded, you can have an overpayment at best. If you don't have, potential civil monetary penalties, depending on, if you identify it internally or if the government identifies it. You can also, have larger issues with licensure if you're, providing services to beneficiaries for utilizing staff that don't meet the requirements. And it's a risk too to the patients themselves, because there's a reason why we require certain background checks, right? We want to make sure that we're going into these people's homes and that we're providing people who, by doing all this screening and verification, we deem are, safe actors. We're not going to be putting these beneficiaries in harm's way or at risk. It's important to also keep in mind that even covered services can be subject to limitations. We're only going to be providing services, that meet the amount and the time that are listed in that plan of care. We want to make sure we're not exceeding that. And there may be changes in payer requirements too. So just make sure you stay on top of what the payer requirements are. Next slide. Okay, so in Louisiana specifically, under the administrative code, electronic visit verification is required for your personal care services. There's an electronic visit verification system that must be used for automated scheduling, time, and attendance tracking and billing for your personal care services. So very important that you are either using the electronic visit verification system that is designed by the department, or you can use an alternative system, but you need to make sure that it has successfully passed the data integration process to connect to the designated EVV system, and that it is approved by the department. Path of least resistance here is going to be to use the system that's designated by the department. Then you are ensuring that you're in compliance because you're using the one that they have specified. But if you would prefer to use a different system, you need to make sure that it's passed the data integration and that it's been approved by the department, so that you make sure that you're in compliance. If you are not using the EVV system designated by the department, or you're using one that's not in compliance, then reimbursement for your services may be withheld or denied. So this is really, really critical that you make sure that you are using a system that is in compliance or the department's specific EVV system. Requirements for proper use of the EVV system are outlined in the Medicaid provider manual, and you have to make sure you comply with those requirements to make sure you're getting paid. So very important that you're using this system and that you train your personal care attendants on how to properly use the system to make sure you're getting paid. I'm going to talk a little bit more about that on the next slide, Gio. So service log requirements. Service logs are essentially one of the biggest pieces of documentation that's going to be maintained for each beneficiary, for each data service that you're having a personal care attendant go in and see a patient. It is essentially the paper trail for the services that are being delivered by your personal care attendants. It contains the name of the beneficiary, the name of the provider and the employee providing the service, the data service of the contact, and the content of the service contact. The start and stop time, as I said previously, start and stop time of service contacts needs to be documented in that EVV system, as well as the location where the check-in and check-out occurs. These are captured within your EVV system. So you start and stop in the system and you input the locations, very important. And the location, may automatically populate from the system, but just make sure, you're doing an internal audit to ensure that that information is properly there. Because we don't want to find this out, 2 years later that for some reason, the location wasn't populating correctly or the start and stop times weren't working. We'd rather identify it now to make sure you're doing those internal compliance audits at least quarterly, just to check a few charts and make sure that that documentation is being prepared appropriately. Reimbursement, as I said previously, only payable for services that are documented in the EVV system and that are documented in the service log. Providers are required to use the service log that is issued by the Office of Aging and Audit Services or another one that is deemed compliant and approved. All portions of the service log must be completed each week. Photocopies of previously completed logs are not acceptable. Service logs must be completed daily as tasks are performed. They may not be completed prior to the performance of a task. That makes sense. You can't document something before you do it. And they must be signed and dated by the worker and the beneficiary or the responsible representative after the work has been completed at the end of each week. So very important. Make sure your workers understand that. They need to sign and date it at the end of that session, and the Benny or their responsible representative needs to sign at the end of the week. Progress notes are located on the second page of that service log and are the means for documenting any observed changes in the beneficiary's mental or medical conditions, behavior, or the home situation that may indicate the need for a reassessment or changes to the plan of care and or individualized service plan changes, and any other information that the personal care attendant deems necessary to ensure the continuity of care for that specific beneficiary. So very important that we are training our PCAs on the use of the EVV system, the use of the service log, signature requirements, start and stop time, location input, and that we're also doing our own internal audits to ensure that we're actually capturing the information correctly after our PCAs input it. Next slide. Other qualification requirements. So they can vary by state, but generally for your employees, for your PCAs specifically, we need to make sure we are doing criminal background checks, reviewing abuse and neglect registries, and that we are reviewing federal and state exclusion lists. I've kind of previously touched on the exclusion issue. It's really important that you are checking the exclusion list, which is different than doing a background check. A lot of providers don't know that. This is a completely separate list. There are two federal lists, the HHS, Office of the Inspector General, LEIE, and the GSA SAM, and then I believe there are like 40 specific state lists as well that also need to be screened. You can certainly work with a third party that does exclusion screening. Just make sure that they actually do exclusion screening and aren't just calling a background check in an exclusion screen, because it's a very different check. For example, somebody can be excluded because of licensure issues. They can be excluded because of a misdemeanor or a felony that happened years ago. And it's important that we're checking different names. So for example, if you have somebody that has had a prior name or a maiden name, we need to make sure we're checking both of those names, because you cannot receive federal dollars, meaning federal and state dollars, so Medicaid dollars, for any individual who is excluded. So we cannot have a personal care attendant going in providing services to somebody if they have been excluded. And a lot of times it gets missed if the person has had a different name previously. And then we have providers come to us who then need to do a refund back to the OIG and to the state for the services that have been provided by that PCA. There's a multiplier that you can use to figure out the amount depending on the length of time that the person worked for the company. But you should be doing that prior to hiring somebody and then monthly thereafter, because these lists get updated at various times. The LEIE gets updated every month, but the state list can really vary. So it's important that you're doing it monthly to capture any changes, and that you're maintaining documentation of those checks so that you can show that we are, making a good faith effort to comply and make sure that the people that we are sending into individuals' homes are not on any of these lists. And it is important, I know I said that there's 2 federal lists and at least 40 states, but it is important to review them all because they don't integrate very well. You would think that everybody communicates together and we can have, one comprehensive list, but that's unfortunately just not the case. So it's important to review all of them. Other potential requirements can include the individual's age, their health status, education, and training. Varies by state, so you just need to make sure that the people that you are employing do meet the specific state requirements. Next slide. So I briefly touched on this previously, but services that are being provided during an institutional stay, this can be a big issue. We want to make sure we're avoiding this. We're not providing services during an institutional stay or billing for services while somebody is in an institution such as a hospital, a nursing facility, a mental health facility, or other intermediate care facilities for those with intellectual disabilities. Under federal law and most state regulations, personal care services are not covered when a patient is within one of those institutional services. So it's important that we know if somebody has been admitted to the hospital or a nursing facility and we discontinue services and we are not continuing to send somebody out to their home. Obviously I would hope when they got there and they realized nobody was there, they would notify you. But it's just very important we stay on top of these things. We realize that somebody's been admitted and we're discontinuing services and not attempting to send a bill out for services when somebody was in an institution. In some instances, it can be permitted to provide personal care services to individuals within some of these facilities, but it has to be under an approved waiver. Next slide. Okay, fraud, waste, and abuse. We have some common examples for you on the screen, but the biggest one is going to be offering medically unnecessary services. If this person really didn't qualify for the services, didn't need them, that's going to be considered waste at best to the system. We don't need to be billing the government for services that if somebody did not need. Or if we're offering more services or staying more hours and we're authorized to support the patient and then trying to get reimbursed for those, that's considered abuse or waste as well. We should only be providing the services that were authorized through that plan of care. If we think that the person requires more, then that needs to be something that is addressed through a change to the plan of care. We should not just try to provide additional services to that person. Providing services by uncertified PCAs, that's going to be considered fraud. We need to make sure that our PCAs meet the certification requirements. We've done all of our screening, very, very important. And that we're maintaining our employee files to show all of the background checks that we've done, and we have up-to-date files for those individuals. Delivering services to ineligible recipients. Similar to medically unnecessary services, we need to make sure that these people actually require the services, that we have a documented plan of care that outlines what they specifically need. Forging credentials, obviously that's fraud. We cannot, forge a signature, if the services were never provided and then we're just signing off on the services, or if we have another personal care attendant signing for services for somebody else, or even worse, just a random person signing for services by a personal care attendant, that obviously that's fraud. That's going to be, a major investigative issue. Billing for services never rendered, making up services essentially, another obvious fraud. And that is something that, we see frequently in personal care audits is, billing for services that were never rendered. That's a lot of the reason why many personal care services have migrated to these electronic systems, is to try to have better tracking and ability to keep track of the services that are being provided, to try to prevent people from billing for services that were not rendered. And again, submitting claims that were provided by an excluded PCA. I just talked about this at length, but make sure you're checking those exclusion lists. Always remember that billing mistakes are bound to occur, But if you identify a mistake or you identify that you were overpaid for a service, we need to make sure we're taking appropriate corrective action. So if that is refunding a claim, then we need to refund the claim. Or doing some sort of voluntary report, we need to take that step. You have a duty to disclose errors when they occur and return overpayments when they are, if you have received them. The government doesn't expect you to be perfect, but it does expect you to try. So very, very important that you do have an active compliance plan. You're doing those internal audits. And if you do identify a problem, take the appropriate corrective action, document what that corrective action is. I frequently have providers ask me if we're doing some sort of voluntary refund, well, is this going to trigger a larger audit? And I can never tell someone no, it's 100% not going to trigger a bigger audit. There's always a risk, right? When you are opening a can of worms with a government entity saying, oh no, we made a mistake, we need to refund this money, it can. There's always a risk. In my experience, however, generally when you are making a voluntary refund, you know, the government appreciates you trying to be a good corporate citizen, and they don't then take more action against you because they want to encourage you to be compliant. So generally, in my experience, you know, the government has worked with us through the voluntary refund, and then there has not been a subsequent audit or investigation of that provider after that refund has occurred. But of course, there's always a risk. Next slide. So I'm just going to run through some sample OIG audit and inspection plans for personal care services, just to give you a flavor of what OIGs around the country are looking at in connection with personal care services. And some of this is going to be similar to what you've already heard, but just to, you know, we've looked around, and these are some examples. So provider practices are being reviewed in connection with cost reporting, improper discharges, transfers to emergency rooms, and reporting of refunds, overpayments, and recoveries. So that's what OIGs around the country are focusing on. So make sure your cost reporting is correct. If you're discharging somebody, you know, again, that it's appropriate to discharge somebody. Again, the transfer to emergency rooms, we can't be billing when somebody is in the hospital, so we need to make sure that we're discontinuing services. And then, you know, overpayments and recoveries, they're reviewing those as well. Next slide. Providers audits are assessing compliance with Louisiana statutes, rules, guidance, or contracts that govern client care and billing practices. So they're going to be looking at, for example, whether those service logs are appropriately completed, start and stop times are there, if your PCAs are properly credentialed, do you have the right signatures? They're going to be looking at all of that to make sure you're in compliance with the state rules and the manuals. Providers they are prioritizing include centers for independent living, home and community-based services, which is personal care, behavioral health, and long-term care. So, you know, again, personal care services are being looked at. We are seeing an increase in audits on personal care service providers. So, you know, if you are not taking steps to actively review your internal practices, it's a good time to go ahead and start working on those quarterly internal audits. Next slide. All right, and now we're going to talk about Medicaid fraud control units, and Les is going to go ahead and take over and start talking about that with y'all. Les?
All right, so I had to unmute myself. All right, so Medicaid fraud control units. These are part of the Louisiana Department of Health, and you know the I guess the single state agency in every state. It's just basically the team that investigates Medicaid fraud, waste, and abuse. In Louisiana, they're fairly aggressive, I guess, compared to some other states, but I see more federal kind of driven audits and I guess criminal findings than state-driven ones, but they are out there all the time. So in addition, like I said, we have the Office of Inspector General collaborates with them, and like I said, in Louisiana, if it's a big it's like topic style audit where they're auditing all of the personal care attendant programs or something like that, usually OIG is involved as well. They're certainly sending them data, but just be aware that there's both state and federal investigations for Medicaid. Go to the next slide. So what are they looking for? Basically, I mean, the first thing and most likely thing to look for is False Claims Act violation. So the False Claims Act is basically just makes it a crime to knowingly present or cause to be presented a false or fraudulent claim for payment or approval to the government. So you don't have to have any specific intent. You don't have to know anything about the False Claims Act. Specifically, you just have to be intending, I guess, to make the payment, essentially, not to commit a crime. So accidental payments maybe wouldn't be, accidentally submitting a claim maybe wouldn't be a False Claims Act violation, but if you did intend to submit it, even if you didn't know every element of the underlying, I guess, statutes that were violated, it can still be you can still be convicted of a False Claims Act. So you can't stick your head in the sand. You can't just ignore problems and expect to, I guess, benefit from that in any way. Lots of times, whistleblowers, former or current employees, are the ones that start, I guess, the investigation by essentially tattling on you. They can receive a portion of the recoveries. Sometimes also they can end up in trouble themselves. Sometimes a whistleblower will go to the feds and explain a bunch of things that actually is part of their job and what they've been doing wrong, and then everyone gets in trouble. But generally, they're going to be working with the whistleblower. In addition, if it's deemed to be a violation of the anti-kickback statute or any of the other fraud and abuse laws, of which there are many, it's also rendered a false claim under the False Claims Act. So this was, I think, under Obamacare. It's when this changed, where they made it essentially a violation of the anti-kickback statute and other laws is itself a separate violation of the False Claims Act. On the next slide, this can really ramp up your penalties. So under just the False Claims Act, not counting, say, anti-kickback and others, you can have fines up to 3 times the program's loss, plus penalties of between $13,508 and $27,018. Wow, that's, I guess, with inflation, that's gone up a lot. But that's per claim filed. Lots of these investigations will involve thousands of claims. So the penalty amounts can just get comical, and you just get completely impossible for anyone to pay, but they use that as leverage over you in litigation. This is lots of times how they'll end up getting settlements out of people. It's because the penalties and fines are just so catastrophically high that no one could possibly risk going to trial. Again, extremely quickly, in addition, there are also criminal penalties. So just because you get a civil False Claims Act penalty doesn't mean you don't have criminal ones going on as well. And you can also be investigated under both laws. So you can have a civil DOJ people and dealing with you under what's, according to them, a civil False Claims Act investigation, which can quickly turn into a criminal False Claims Act investigation. And it could have been the entire time. Sometimes the criminal guys are just sitting back watching what goes on with the civil investigation or what goes on in audits. So if you get audited by just one of these Medicaid auditors, sometimes the criminal investigators are sitting there watching the results of that audit. So you think you just have an administrative action going on, but it's actually criminal at the same time. So regardless of who's auditing you and what law they're trying to, I guess they're investigating, you've got to be on top of your game when it comes to your documentation and your internal compliance practices. The next page. So anti-kickback statute, another one of these, one of the criminal statutes, and this is similar to what we talk about Stark law a lot. That's just for physicians. Anti-kickback is the kind of similar law for all services, and it essentially is for bribes. So anyone who knowingly and willfully solicits, receives, offers, or pays, and then there's a separate part of the statute that it's essentially the same language, except it's anyone who willfully receives. This is the payer version, and there's you can't receive any kickbacks, offers, or payments of any remuneration either. So it attaches criminal liability to both the payer, the person bribing someone, and the provider. So you can't pay or receive any remuneration in return for referring or arranging for services payable by any federal healthcare program, or for purchasing, leasing, ordering, or arranging any goods or services that may be paid for in whole or in part by federal or state healthcare programs. So that's Medicaid falls in with this, obviously, because it's a state healthcare program with federal dollars. And so you have this federal anti-kickback statute, and you'll also have a similar state-based anti-kickback and sometimes Stark laws as well. that'll be similar language, and it'll just be a state authority. Sometimes states have a little bit broader exceptions to the state-based anti-kickback statute, and they may not cover exactly the same scope of services, but generally they're definitely going to be prohibiting all the things that the federal anti-kickback statute prohibits. And so anything that violates that, that's really what the first thing we look to, and we look to the state versions, because they usually mirror the federal version pretty closely. And so we first look at that, and then we look to see if there's any state versions that you can run afoul of as well. So again, under the Affordable Care Act, a person need not have actual knowledge of this section or specific intent to commit a violation of this section. So you don't have to know that you're committing you're actually this payment or whatever, this contract terms, or actually violate the anti-kickback statute. It just has to be on purpose. So essentially you have to intend to enter into this contract, and that's enough. You don't have to know that that contract is going to violate the anti-kickback statute or False Claims Act or anything like that. You just have to essentially intend to actually do it. It's pretty broad actually now. So go to the next page. So the penalties on the anti-kickback statute, and again, this is in addition to False Claims Act penalties. So you can see how quickly this can add up. But you can get actually time in prison, 10 years, fine up to $100,000 per violation, exclusion from participation in federal and state healthcare programs, and then CMPs. This is a separate statute called Civil Monetary Penalty Statute that basically it contains a lot of penalties for violations of lots of different statutes, but one of them is anti-kickback statute, and under it you can get up to $50,000 per violation, and assessments equal to no more than 3 times the amount of remuneration paid. So total amount paid, to the provider, the referring provider or whatever, and then 3 times that. So $50,000 per violation, that would be, I guess, every payment, every kickback, and then 3 times that amount, 3 times the amount paid under the arrangement. Most courts have adopted expanded reading of knowing and willful, and they essentially use this one purpose test. So if the payment was intended to induce a physician or anyone else to refer a patient, and that's just one purpose of it, so there's 3 other legitimate purposes for the payment, then you violate it. So if any part of your intention was to get this person to send referrals, it's violated. Even if part of the payment was, I don't know, to rent some space from the doctor or to pay for something that the doctor provided. You just cannot pay for referrals, period. And it really, under the anti-kickback statute, you want anything you do structure under there that is, I guess, in any way remotely risky at all, make sure that you get with a healthcare attorney and have them structured in compliance with the safe harbor, because it's not impossible to do. And even where we can't fully safe harbor a particular arrangement, we can get it really, really close, and we can build in additional safeguards that kind of make it difficult for the government to claim that you were violating the statute, because we may not meet every single element of the safe harbor provisions, but we'll meet 5 out of 6 of them, and then we'll add in 3 or 4 different additional kind of safeguards to help prevent overutilization or steering of patients or any of the other things that the anti-kickback statute seeks to, I guess, eliminate. Let's go to the next page. All right. So let's look at, I guess, the 2024 annual report for all the Medicaid fraud control units in the country. All right. Looking at the total recoveries, they had $1.4 billion recovered, and this was in 493 civil settlements and judgments, and they excluded 1,042 individuals or entities. It's a pretty decent amount, definitely a lot of money. There's certainly a lot more out there, but 493 civil judgments. Let's go to the next page. Now, their criminal convictions. What's really striking here is the percentage of total fraud convictions that are leveled on PCS attendance. In this 2024, you got 298 out of all of them are PCS programs, when there's only 25 home health agencies, 51 mental health facilities, 93 nurses. So it's a huge percentage. And I think part of the reason, having handled a few PCA program audits way back in the day, I think part of you're just ripe for for errors. You've got a lot of fairly low-paid employees who are lots of times semi-new to the program, and some of them just don't care about the job as much as you do, or documenting as much as you do. And so if you're not monitoring their work product, they may start to lie or make up things on, in their documentation. And I think it lends itself. It's a risk. It's a big risk area in personal care attendant programs, that you don't really have quite as much of a risk in home health or with pharmacy or with mental health. It's just they have longer term employees. The audits I've dealt with, a lot of the overpayments were basically because this brand new employee who promises to do all the right things and gets trained right just ends up not doing the right thing because they don't want to, and then they lie. So it happens a lot in your area, and you really have to watch your people. Some of them you may not know that well, and you have to ensure as an organization that everyone is properly documenting their services, and that you're dotting all the I's and crossing all the T's. So majority of these were fraud. There were 817 of these convictions were fraud. The others were patient abuse and neglect. Those are some of the kind of worst situations. When they come after patient abuse or neglect, it's usually a pretty bad provider. So I don't really feel very bad for them very often, but I do feel bad for providers when it's some new employee has gotten you kind of crossways with the government. It's not your fault. You trained them right. They just lied to you, and they lied to everyone, but it's still, you're the one that's getting paid. You're the one that's going to have to repay the overpayment. The real key isn't in preventing all errors or situations like that. It's how you respond to them when you discover them. That's much more important. Go to the next slide. So here it is over time from 2015 all the way through 2024, and you can see it's a huge percentage. I mean, the lowest it ever was in 2023 at 34%. Highest it was 48% of all the criminal enforcement's actions. That's a shocking percentage considering all the different kinds of providers that are out there that provide far more services than personal care programs. It's just, these are ripe for fraud and abuse, and they focus on them, and they usually catch people. So I think they probably come into most of these investigations assuming they're going to nail you. So I guess keep that in mind and make sure that your records are near perfect. They need to be. Let's go to the next slide. Okay, so let's talk about some examples. One is Ohio Personal Care Agency. 2016, auditors reviewed and tested 6 of the personal care aides employed for first aid compliance, determined that none of them were properly certified. They expanded the review and determined that an additional 12 aides were not properly certified, and they discovered that the required first aid certification was not a requirement of the company hiring. Your onboarding process needs to be well thought out. I've seen this in so many different clients and different kinds of providers as well, where they need a particular kind of person in a particular role, and so they just run out and hire anyone who claims to be that, and they really haven't verified everything, or if they did verify it once, they don't continually verify it, and so that person who was certified in 1 year isn't anymore because they didn't stay on top of their licensing obligations, and before you know it, you've got a massive overpayment, and this person's been seeing patients or doing whatever every day for you for maybe a year, and you had no idea that they weren't allowed to do any of that. And it sucks because lots of times it's just turning in the right paperwork first. And here, making sure people are CPA, first aid certified. That is not hard. It's not like you're telling someone to make them go to school for another 4 years. This is simple. These are weekend kind of courses. This can be done if you know about it. And I think when you don't have good organization, your onboarding process, you're not really checking all the things like checking exclusion databases before they actually work, doing the background checks, making sure they're properly trained on not just your practices, but also on things like this that are just required. You're supposed to be, first aid certified, and if they're not, well, you don't meet the requirements. So, in addition, in this case, they discovered many other errors, likely just a lack of organization and I guess dedication and compliance, I'm sure, across the board. But the services were submitted prior to a physician signing the plan of care. So this is part of your billing processes. You should have someone pre-checking your bills and your records before you submit. They should have picked up on the physician's on plan of care. Physician signatures on the plan of care were not dated. That's probably on purpose. doctor's probably coming in 2-3 weeks after the fact and being asked to sign 15 plans of care, and he's just intentionally, because he feels a little guilty, not putting a date down there. Lack of a plan of care provided, so just don't have one at all. And plan of care didn't authorize the services provided, so it just wasn't a very comprehensive one. The first two really aren't, I say those a lot, but if services submitted prior to them signing a plan of care, this is easy for your billing team to do. You know, before they submit a claim, they should be checking this, or someone should. Everything should be greenlit before, or you know, you may have a pre-bill team who kind of looks over the charts before they send it to billing. But either way, however you organize your billing services, you've got to be checking things, at least all of the required elements, before you submit the claim. Just don't. That can actually help. If you implement from the top down a policy where you will not allow a bill to be submitted until whatever needs to be checked is checked, sometimes it's going to slow up a bill, but that's going to make it, it's going to bring it to everyone's attention much more quickly. And things won't sit around for months on end if no one's able to submit a bill. Like, you're going to fix that problem, or whoever needs to be involved is going to fix it if no one's able to submit a bill. So I tell clients, you know, put in hard and fast rules like that if you need to, and that'll force your team to, you know, to get on the ball and finish their work on time. Affect the, you know, the record before they submit a claim. Let's go to the next slide. So anyway, this one, they had $2.1 million in penalties. So that could have been worse. Virginia Personal Care Agency, but you can see it gets really expensive. That's probably not a whole lot of penalties. That's probably mainly just overpayments. 2.1 million, depends on how long it went on, but if they had that many aides who just weren't even certified, you know, they're likely denying payment on each one of those stays. If they added some penalties in, they had every right to, but it sounds to me like it wouldn't even need to. If you're that systemic and you don't have any of your people certified, none of them are qualified, none of them should be providing care. So in Virginia in 2015, we had a 4-year span, approximately 7,800 fraudulent claims were submitted to the Virginia Medicaid program. Management directed employees to alter office records. Do not ever do that, including home health aide timesheets as an attempt to conceal their behavior. Never, ever, 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 ever allow your people to alter records after the fact. Never, ever. There are certain little things that are allowed to be corrected in the record up to the fact, but if you've received like an audit request, you need to get your attorney involved before you tweak anything in that record. All right, so then the husband and wife, in this case, their husband and wife management duo charged with healthcare fraud, false statements related to healthcare matters, alteration of records, and aggravated identity theft. It was a joint investigation by the FBI and the Virginia Attorney General's office. The husband was sentenced to 63 months in prison, while the wife received 25 months. And they were forced to repay $1.5 million penalty. They went easy on that, but these people spent 63 months in prison and 25 months. You do not want to be in jail. So pretty harsh, but you can see how, just multiply those per claim fines times 7,800 and see how much they could have asked for as far as penalties. It could have been just ridiculous. $100 million. I mean, I've seen $50 million cases. That's just all penalties. Nowhere near that much in actual reimbursement. Let's go to the next slide. All right, here's a big one. DC Personal Care Agency, 2015, excluded nurse used a fake name, forged several signatures to obtain a provider number. And over the course of 4 years, her nurse and her family members participated in a massive fraud scheme to fake timesheets, fake patient files, fake employee files. So this was just a complete fraudulent operation. Nothing was really real, or most of it wasn't, and all their documentation was falsified. They apparently had a lavish lifestyle with mansions and expensive luxury vehicles. They will, if they come and nail you, by the way, they're going to come after your cars and your houses and all that stuff. They always seem to do that. If the business doesn't have enough to repay the entire amount of the fines, they're going to come after the owners, and they're going to take things that maybe don't have much connection to the underlying crimes, but they got just enough for them to qualify for civil forfeiture. I think it's a lot of different cases and different ideas about how far they should be taking that, but they take it pretty far, and just, you don't want to put your entire, worth at risk just to get a little bit extra Medicaid reimbursements for your business. It's just not worth it. In this case, 25 people were charged with participating in the schemes, including fraud, kickbacks, false billing. It included personal care aides, recruiters, other collaborators. The nurse was sentenced to 10 years in prison. Her husband got 7 years. And here's where they started really jacking up things with the penalties. So the judge ordered forfeiture of $11 million from 76 different bank accounts. I guess they were trying to hide a lot of their revenues. But the residence worth $1 million, $73,000 in cash, 5 luxury vehicles with purchase price of more than 400 grand, not that much, but say $80,000 vehicles. And the judge imposed a forfeiture money judgment of nearly $40 million on both defendants and ordered them to pay over $80 million in restitution. Now, they're not going to pay $80 million to anyone, obviously. They're not going to pay $40 million. They're probably not going to pay the 11. I'm sure most of the money's gone, but everything they had is going to get taken from them. You know, and then they're in prison, so they may not care that much about that. But anything they hope to leave to their children, gone. They're going to take it all. And so it really does not pay at all. Just do not engage in Medicaid fraud at all, ever. It's too harsh on how they can stack up the penalties, and it's too harsh on what they can collect and take from you if you're convicted. You know, it can just absolutely ruin you. I promise you, it's not worth it. It is much easier to run one of these businesses in compliance with the law and make a little money than it is to try to make a little bit more money and end up in 10 years in prison and broke and penniless. So, let's go to the next page. All right, so here's, I guess the rest of this will be a little bit about the risks of investigations and what happens when one goes on. So responding to audits. Let's say the FBI shows up and wants to talk to you. First thing you're going to want to do is make them think that you're not a criminal and no one has committed any crimes and they're looking the wrong way. Everyone wants to explain away everything immediately. Bad idea, because the FBI, this whole slide's about 302, Form 302 memos. These are basically just memos that document what went on during an investigation, an interview of a witness or a suspect, whatever. So what they'll do is, instead of recording these things, they will just basically write a memo, and it will be the FBI agent's word on what was said, how you responded, how did you seem nervous during the interview? All of that will be written in the memo, and it'll just be based on what they said, not what actually was said. So lots of times when they've claimed that someone's lying, it's based on what they were told this FBI agent. And they could have easily just recorded the whole conversation, right? But if they'd done that, that would be allowed into evidence in the case. And if they want to claim that you're lying about something, they can do it a lot easier if there's not a video recording of the conversation. So that's why they don't tape record these things. They do not want to have the actual conversation end up in court, because it might not be as beneficial to their case as they would like it to be. They like these memos. And once it says here that they typically work in pairs and they'll support each other at trial. One FBI agent's not going to say, well, I don't think he was really saying that. They're going to back each other up. And they've really abused, in my opinion, this lying to the FBI charges, lying to federal officers charges so much that, and this is part of the way they do it with the 302 forms, that frankly, I won't even let a client talk to them anymore at all for any reason. I don't care if it's just their next door neighbor. Just don't let them talk, ever. I don't see anything that you really gain by it. You don't know if you're, say, a potential whistleblower type and you are wanting to, I guess, tell the FBI all the things that your employer's doing wrong. You don't know if they might want to put a little leverage over you, or they may think that some of what you did in your job was also part of the crime, and they may decide that they don't want to not come against you, because then it may look like, if you end up being a witness, it may look like they gave you a sweetheart deal, like you just didn't prosecute them, so they would say whatever the FBI wanted. So they'll sometimes just pop everyone with charges, or at least lying to the FBI type charges, in order to get leverage over them for use in, I guess, the prosecution of the owners or whoever they're really targeting. But I've seen witnesses end up with charges. I've seen victims end up with charges. I've seen, obviously, suspect end up with charges, not related to with the crimes they were investigating, but just for lying to the FBI. And I'm not aware of any of them. Well, one of them where they were trying to lie, but in most cases, they're not even trying to lie. They're just glossing over things. So we'll look at some examples. Let's go to the next slide. All right, so what can't you do? You can't lie. Absolutely, under no circumstances can you lie in any way. But they can lie to you, and they're going to lie to you. Most of what they're going to tell you is probably not true. If they say, we don't really think you did anything wrong, we're just thinking that maybe something, you can't believe a single word they're saying. It might be true, but they might be telling you that as a strategy. So in the Supreme Court case, Frazier Cup, a homicide suspect was interrogated by the police and falsely told that an accomplice had already implicated him in the murder. Based on this lie, the suspect confessed to the murder. The Supreme Court ruled that use of trickery and deceit is permissible, depending on the totality of the circumstances, provided that it does not, quote, shock the conscience of the court or the community. All right, so basically, criminal activity, such as stealth and strategy, are necessary weapons and for police officers, and they're going to do that. You're not allowed to, though. So what's some examples of situations that did shock the conscience? It's really not going to happen in your case, in all likelihood, but investigator lied about his identity and introduced himself as the defendant's court-appointed attorney. That took some guts. That shocks the conscience. I don't disagree with that in any way. Investigator who poses as a clergyman in an effort to get a confession under the guise that constitute behavior that shocks. So impersonating the defendant's lawyer or impersonating clergyman, those were kind of stepping up the lines, but most of the time they can lie their butts off to you. They can tell you just about anything, and anything you tell them that's not true, you get charged with. So go to the next chart, next page. Okay, misstatements, hyperbole, exaggerations. This is where I say they've abused this law pretty bad, in my opinion. So in the case out of Spokane, Washington, government conducted an investigation of a controlled substance prescribing billing practice of a licensed healthcare provider. So this is the lie. This guy, whatever they was talking to the FBI person, said that he 99.99% of the time checks the vital signs. We got charged because it wasn't 99.99% of the time. It may have been much lower, but they didn't say here how much lower. It could have been 80%. It still may have been very high. But if you exaggerate, they can charge you with lying to the FBI, and that's like a 5-year charge or something like that. It's not a 5 years in prison, $250,000 fine. It's not nothing. So if I were you, I wouldn't talk to an FBI or DOJ for any reason at all. Not as a witness, not as a victim, not as a suspect, not as nothing. I would have my lawyer talk to them at all times. That may not always be practical, but I would be very, 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 very careful before talking to them directly. I have a lawyer do it. I'll tell them what you say, but it's risky. I don't trust them. I don't think you should trust them either. Just the way it is. That's the world we live in today. But in this case, they didn't charge with any of the underlying billing violations. So what they're investigating turned into nothing. All they charged him was making a materially false statement to the FBI. 5 years in prison, $250,000 fine. Guess what this person will do now in order to help the government? Anything they want. They'll say anything they want them to say. They'll implicate anybody that FBI wants them to implicate, in all likelihood, because look, they're facing 5 years in prison and $250,000 fine. It's a lot of leverage. So don't get yourself in a position where you expose yourself like this. That's why I would record every conversation with them. I would insist on it. I would not care. If you want to talk to me, interview me, it's going to be on video. And they won't like it, but I wouldn't care. If they want the video, if they want the interview, that's what they're going to have to do. And that's what I would suggest, really. It's, again, not every situation would always call for that, and it may be a little bit overboard, but I guarantee you these people in this situation probably wish they had done that, right? Go to the next page. And I say this as someone my brother works for the DOJ, y'all. He works in the DC office, so he is a prosecutor for them. But I just feel like I've abused it a lot. Little BS cases like that, where it's just someone just kind of making it's hyperbole, and that's all he did was kind of exaggerate and got charged. They do that a lot. This is not a one-off. So self-audits are not just encouraged, they're required. They're going to look and see if you have anything bad happen. One of the first things they're going to do is say, well, let's look at your compliance plan. If you don't have one at all, it's not going to look good for you. That's not a crime in and of itself, but it's, it shows that you're not even trying. And they're going to keep that in mind for good. Billing errors and overpayments will be promptly investigated and returned to appropriate payer. And that's a Civil False Claims Act violation, but you saw how wildly inflated those fines can be if you violate it. So you need to do it whether it can come with criminal charges or not. The fines can be catastrophic and ruin you. Ensure that your staff is properly qualified and screen your staff. So look at your onboarding process. Look at it closely. Make sure that it is addressing all of the needs. So if you have to have all of your staff be first aid qualified, make sure that your HR people or whoever does not allow someone to be scheduled until that's been satisfied. Just do not allow it. And if that causes some problems in your organization, because I don't know, you need someone there today, fine. That's going to make you actually address the problem. Don't just go forward anyway without complying. Always make sure that when you have any knowledge of any non-compliance, you are responding to it like you would expect, like they would expect you to respond to it. So just kind of pretend that the FBI or DOJ is in the room with you when you decide how to respond to something. And if you do that, and you're always honest and you're always forthright, with your staff, and you work through problems together, you won't have big problems with whistleblowers running out trying to tattle on you all the time. You won't have as many problems as some of these providers that have been caught. But as you can see, there are lots of audits out there involving those kinds of providers, personal care attendant programs, and you need to be careful. So I think that's about it. If you have any questions, we'd love to take them.
So it looks like there's not any questions at this time, so I'll just close.
Okay.
So thank you so much to our presenters, Ashley and Les, for that information, and thank you to our attendees for joining us today. Like I said before, I'll be sending a copy of the PowerPoint slides tomorrow, and if you have any further questions, please reach out to Les and Ashley. Have a great Tuesday, guys.
Thank you.
Bye.